Yes, I am.
Do you feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, sir, I do.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
And Mr. Mason, your signature as it appears in the documents, is that your true and correct signature? And did you only sign once you were satisfied that you understood what you were signing?
Yes, sir, I did.
All right, Ms. Beasley, do you believe Mr. Mason to be competent today?
Yes, Your Honor.
And did you explain to him his legal and constitutional rights?
I did, Your Honor, and he understands everything.
Okay, Mr. Mason, you're charged by indictment with a third-degree felony offense of fraudulent use or possession of identifying information, 5 to 10 items. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. I see here that the proposed plea agreement is that you're going to be pleading guilty to that charge in exchange for the state's recommendation that your punishment be assessed at 6 years confinement in TDC with a $1,000 fine, court costs of $290, and reimbursement fees of $85. Also see here that the state is asking the court to consider under section 1245 several cases, another fraudulent use or possession of identifying information, actually 2 charges of that same category, and also an unlawful possession of firearm by a felon with a weapon forfeiture in this case. Is that your understanding of the plea agreement, Mr. Mason?
Yes, sir, it is.
All right, and that's what you're asking the court to approve today?
Yes, sir.
I find that the plea agreement would fit within the legal range of punishment. So at this time, Mr. Mason, I'm going to ask you, how do you plead to the fraudulent use or possession of identifying information with a number of items being 5 to 10?
Guilty, Your Honor.
And Mr. Mason, are you pleading guilty because you are guilty of committing that offense and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this charge today?
No, sir.
All right. The court will accept the defendant's plea of guilt at this time. Ms. Beasley, is there any objection to State's Exhibit 1?
No, Your Honor.
All right. State's Exhibit 1 is admitted into evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Yes, Your Honor. I'd ask that my client be allowed to testify.
Go ahead.
Yes, sir. I was arrested,
A
sir.
second. Michael, just a second. State your name for the record, please.
Michael David Mason Jr.
Now, Mr. Mason, you're actually currently being held in the custody of the Gregg County Jail. Is that correct?
Yes, ma'am, it is.
And prior to that, previously, early sometime last year in 2020, I was appointed to represent you on the cases that are before the court at this time. Is that correct?
Yes, ma'am.
And we've had a chance to go over the police report, talk about all the evidence in the case, and so you understand and believe that today's plea is the best resolution of all those cases. Is that a true statement?
Yes, ma'am.
Okay. But I believe there's something that you wanted to explain to the DA office as well as to the court at the time of the plea?
Yes, ma'am.
At the time of the plea, you were, at the time of the arrest, you were also, had somebody else with you. I believe your dad was with you. Is that correct?
Yes, ma'am.
And what is it that you want to explain to the court and to the DA's office?
Prior, I was arrested in Denton County, and I lost my vehicle up there. Somebody moved it off the side of the road while I was in jail. It was out of gas. I went walking and I got arrested. And I went back up there to get it in my father's car. I was up there walking around looking for it. And when I found it, I called my dad to come up there. And
okay, so let's shorten this for the court. Are you telling the court and the DA's office that you are responsible for these offenses and not your dad?
yes. Everything in that vehicle was mine. Everything.
Okay. So you're acknowledging that your dad was changed with the very same type of offenses
Yes,
from what you're here today?
yes, ma'am. He
Is
was.
that correct?
Yes, that's correct.
Okay, and you're letting the DAs know as well as the judge that you're responsible for for everything that was found in that vehicle?
Yes, my dad was only in the vehicle because his car broke down and he was driving because I was falling asleep. Everything in the vehicle was mine.
Okay. Pass the witness.
No questions, Your Honor.
Okay. All right. The court has reviewed the evidence in this case, and I do find that there is enough evidence to convict Mr. Mason of this offense. The court will follow the plea agreement reached between the defendant and the state, and the court will follow the state's recommendation. Court hereby convicts Mr. Michael David Mason Jr. of the third-degree felony offense of fraudulent use or possession of identifying information. Court assesses his punishment at 6 years confinement in TDC, assesses a $1,000 fine, orders him to pay court costs of $290 and reimbursement fees of $85. The court also takes into consideration under section 1245 those offenses listed in the terms of the plea bargain on the judgment. Court orders the forfeiture of the weapon seized in conjunction with this offense, and the court awards Mr. Mason 326 days credit for time that he has spent in jail on this cause. Mr. Mason, I'm going to ask that you be fingerprinted there in Gregg County where you're in custody so that they can take that judgment and mail it back to Van Zandt County so we can put it in our records. Once you're fingerprinted, that information will be sent back here, and we wish you luck, sir.
Thank you very much.
And is there a member of the jail staff there with you, Mr. Mason?
No, they're not here. They put me in a room, but they're coming back. I know.
Okay.
I'm supposed to fingerprint this page underneath your names. Right here.
Yes, sir, exactly. If you'll, yeah, thank you so much. Yes. If you will just remind them and ask them if they would be gracious enough to fingerprint you, to fax us a copy of that, and to mail the original back to us. And if they have any questions, they can just contact my court.
Thank you very much for your time.
You're very welcome. I appreciate your help today.
Judge, we're ready on that plea on Joni Jackson with Mr. Hubler.
And Judge, do you have the evidence before you on this case?
No, ma'am, I don't. I have a couple copies of the judgment and some things, but I don't have the stipulation of it. All right, Miss Jackson, if you will raise your right hand, ma'am. Ms. Jackson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes, sir. Yes,
Okay,
sir.
you can put your hand down. And yes, please speak up as they indicated to you. Is your name Joni Denise Jenkins Jackson?
Yes, sir.
And Miss Jackson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. James Ugler. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there, do you have any questions about any of the documents that you have read and signed today?
No, sir.
And your name, as it appears throughout the plea agreement there on the paperwork, is that your true and correct signature? And did you only sign those documents once you were satisfied that you understood what you were reading and signing?
Yes, sir.
Mr. Ugler, do you believe Ms. Jackson to be competent today?
I do, Your Honor.
And you explained to her her legal and constitutional rights?
Yes.
All right, Ms. Jackson, you're charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. that carries a range of punishment of not less than 5 years or more than 99 years or life confinement in TDC, and a fine not to exceed $10,000. You understand that full range of punishment?
Yes, sir.
And I see here, Ms. Jackson, that the proposed plea agreement is that you're going to plead guilty to that offense in exchange for the state's recommendation that your sentence be assessed at 10 years confinement in TDC, a $3,500 fine with $180 restitution, $290 court cost, and $65 reimbursement fee. And you would also receive 303 days credit for time that you have spent in jail on this cause towards that sentence. Is that your understanding of the plea agreement and what you're asking the court to approve today?
Judge, the state has reduced the fine in this cause to $1,500 from $3,500. Ms. Jackson was originally going to take probation with some extended conditions. So when she decided to take TDC time, we adjusted the fine, and that is reflected on the judgment at the jail, but not the one before you.
Okay. So,
That is correct.
okay, so the court will revise its admonishment to indicate that the proposed fine in the plea agreement is $1,500. Is the remainder the understanding of your agreement with the state, Ms. Jackson?
Yes, sir.
Okay. So, Ms. Jackson, I see here that would fall within the range of punishment for this charge. So let me ask you then, how do you plead to the first degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams?
Guilty, sir.
And Ms. Jackson, are you pleading guilty to that charge because you are in fact guilty of committing that offense?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Any objection to States 1, Mr. Ugler?
No objection to states 1 as marked and offered.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything from the state,
No, Your Honor.
from the defense?
No, Your Honor, thank you.
Ms. Heisel?
Yes, Your Honor. Ms. Jackson was driving a vehicle that was pulled over for an expired registration sticker. When the officer got closer and did a little more investigation, he determined that that registration sticker actually did not belong to the vehicle it was attached to. As the officer was questioning Ms. Jackson about this, he asked for consent to search the vehicle, which she denied, but he was a canine officer and did deploy his dog. There was alert on the vehicle. And so the officer searched the car and there were baggies of methamphetamine found in multiple locations in the car. And the drug labs came back at 6.85 grams of methamphetamine, Judge.
Mr. Ugler, any objection to that summary?
That's all accurate, Your Honor.
Thank you. All right. Then based on the evidence, Ms. Jackson, the court finds that there is sufficient evidence to convict you of this offense. Court will follow the plea agreement in your case. Court assesses your punishment, convicts you of that offense, and assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice for you to pay a fine of $1,500, $180 restitution, $290 court cost, $65 reimbursement fee, and awards you 303 days credit towards your sentencing in this cause. Ms. Jackson, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'll have you go with the bailiff deputy to be fingerprinted. Good luck to you.
Thank you.
You're welcome.
Judge, Ms. Beasley is ready on, Perry, Shelby Perry.
All right, court call CR 19-225, State versus Shelby Lynn Perry, set for motion to adjudicate. Go ahead, Ms. Beasley.
Yes, sir. I'd ask for an additional pretrial setting. I need a chance to talk to the prosecutor and try to get this resolved.
Okay. Court will set this for the contested docket on June 29th. That should give you a little over 30 days to get the information that you need and have negotiations. So we'll set this at 9 a.m. on June 29th.
9 a.m.?
Yes, ma'am. It's that would be the contested docket day. So we would have them over to the courthouse.
Okay, and what day is that, Judge?
That's Tuesday, June 29th.
Like, should be excused, Your Honor?
Yes.
Well, you have to wait until somebody takes you out. Which one? Clifton?
Basically, the other two are in here also. Mr. Clifton will be next.
Okay. CR 17357, State Anthony Wayne Clifton, set on motion to revoke.
That is correct, Your Honor. I'd ask for additional setting. He has several other criminal charges that have just recently got into the DA's office, and I don't have access to those. So I need time to get the discovery on the brand new cases, try to resolve everything at the same time.
Has he been arraigned on the new cases? Do you know?
No,
They're
sir,
not
Your
indicted, Judge.
I'm sorry,
They're
Miss.
unindicted. They're unindicted.
Okay, so when you say they're in the DA's office, they're unindicted.
Correct.
Do you have any scheduled grand jury on those cases, Ms. Heisel?
Judge, I do intend to take at least one of those to grand jury tomorrow. I have made a offer on that and the MTR combined. And we opened discovery, I believe yesterday afternoon, Miss Beasley. So if you don't have it, if you'll just contact Heidi, hopefully to resolve both of those together.
Yes, I believe she contacted me late yesterday afternoon and we discussed some issues, but I need to review all that discovery before I talk to my client.
Okay, we'll put this on the contested docket also on June 29th. And if we don't have it resolved by then we can consider an additional setting.
May he be excused, Your Honor?
Yes, ma'am.
Next one I have is Austin Walker, Judge.
CR 2200 versus Austin Lynn Walker, set for docket call.
Correct, Your Honor. It's my understanding that the co-defendant's case is set for June 1st, and the DA's office has indicated to me that they prefer trying to resolve her case, and then we'll be able to resolve our case. So I'd ask for additional setting.
Do you believe that the case will be resolved at the next setting?
Judge, I don't know. That's totally dependent on the co-defendant who's set for June 1st.
Well, if the co-defendant's case is resolved, do you anticipate this case will be resolved?
I'm hoping so, yes, sir. But the case has been reset several times for the co-defendant to get their case worked out. It hasn't been worked out yet. So I don't honestly anticipate that it's going to be done anytime soon.
All right, we'll set Mr. Walker then for an additional docket call on July 1st. And that'll be at 1:30.
Yes, sir. May he be excused?
Yes, ma'am. That's also in CR 2232.
Okay, Judge, Ann Thompson is ready with Harley Davidson Cox.
All right, this is CR 2155, State versus Harley Davidson Cox. Hearing on pretrial.
Yes, sir.
Do you have any contested pretrial motions?
I have no contested pretrial motion, Chairman.
All right, there being no contested pretrial, court will set Mr. Cox then for docket call on July 1st.
Yes, sir. Maybe excuse, Your Honor.
Yes, ma'am.
All I have, maybe excuse, sir.
Yes, ma'am. Thank you.
Okay, Judge, he's gone back to get the others, the one for Mr. Sanders, Mr. Smith, and Mr. Lander, and I'll let you know more later.
What about Mr. Flores? Has he appeared at the jail for Miss Beasley?
Not yet.
Okay.
Was that?
Memory's good.
Oh.
All right, we're ready for Brian Smith and Corey Farrell's plea.
All right, this is cause number CR 17-145 and 2019-189. Mr. Farrell, if you'll raise your right hand, sir, please. Mr. Farrell, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, good. You put your hand down. All right, Mr. Farrell, your name is Corey Lance Farrell, is that correct?
Yes, sir.
And Mr. Farrell, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bryan. Are you pleased with Mr. Smith's representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your cases with him and have all your legal questions answered?
Yes, sir.
Anything about the paperwork that you have read and signed today that you do not understand?
No, sir.
Okay, and your signature as it appears in the paperwork, is this your true and correct signature? And I'm going to show you right here what I'm looking at. Is this your true and correct signature?
Yes, sir. That's it.
All right, and you've only signed these documents once you were satisfied that you understood what you were reading and signing, correct?
Yes, sir.
Okay. Mr. Schmidt, do you believe your client to be competent?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, sir.
All right, Mr. Farrell, in cause number CR 17-145, you appeared before the court. Back to it. You appeared before the court on November 9th of 2017, and you pled guilty to the offense of assault of a family or household member with a previous conviction, which is a third-degree felony. The court heard the evidence on that day, found that there was sufficient evidence to convict you. However, the court deferred a finding of guilt and placed you on community supervision for a period of 4 years. It was during your period of community supervision that the state filed a motion to adjudicate and revoke your community supervision. Have you had an opportunity to review that document with your attorney, Mr. Schmidt?
Yes, sir.
Mr. Schmidt, does your client waive the formal reading of the state's motion to adjudicate?
We do, Your Honor.
Is it his intent to plead true to counts 1 and 3?
That is correct, Your Honor.
All right, and Mr. Farrell, in cause number 2019-189, you appear before here. You appeared before the court, the county court at law, on June 3rd of 2019, and you were convicted of the misdemeanor offense of driving while intoxicated, a Class B misdemeanor. Your sentence was assessed at 180 days in the county jail and a $500 fine, and that sentence was subsequently suspended, and you were placed on community supervision for a period of 18 months. Mr. Schmidt, does your client waive the formal reading of the state's motion to revoke in that cause, and is it his intention to also plead to counts 1 and 3 in that motion?
Yes, sir.
Okay. All right, Mr. Farrell, then in cause number CR 17-145, I'm going to ask you at this time, how do you plead to counts 1 and 3 as contained in the motion? Are those counts true or not true?
True.
And in 2019-189 to the misdemeanor offensive driving while intoxicated, are those counts 1 and 3 true or not true in that motion?
True.
And Mr. Farrell, are you pleading true to each of these counts in each of these cases because those counts are true and for no other reason?
Yes, sir.
Mr. Farrell, has anyone threatened you, forced you, or made you feel like you had to plead true to either one of these cases?
No, sir.
All right, the court will accept the defendant's pleas of truth at this time. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of truth in each case?
No, Your Honor.
All right, the defendant's waiver of rights and plea of truth is admitted in each case respectively, and the court does take judicial notice of the defendant's judicial confession in each case. Is there anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
All right, the court in cause number CR 17-145, based on the evidence, will follow the plea agreement in this case and also the other case. Court finds that Mr. Corey Lance Farrell has violated the terms and conditions of his community supervision. As a result, the court hereby adjudicates Mr. Farrell's guilt in CR 17-145, orders his community supervision to be revoked, assesses punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders him to pay the balance of his financial obligations. The court does award Mr. Farrell 240 days credit towards the sentence for the time that he has spent in jail on this cause. With regards to 2019-189, the driving while intoxicated, the court finds that he has violated the terms and conditions of his community supervision. The court hereby revokes his community supervision, assesses his punishment at 69 days confinement in the Van Zandt County Jail. Court gives him credit for time served at 69 days, orders him to pay the balance of his financial obligations. Mr. Farrell, when you are released from the Texas Department of Criminal Justice, I'm going to order you to report to the Van Zandt County Courthouse and speak with the court compliance officer, Ms. Bonnie LaPrade, so that you can make arrangements to discharge the money that you owe on these cases. Your failure to do so will result in a warrant being issued for your arrest. Do you understand?
Yes, sir.
All right. Good luck to you, sir. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you.
So I have my big excuse, Your Honor.
Yes, sir. Good to see you, Mr. Schmidt.
Good judge. Yeah.
Okay, Judge, Mr. Sanders is ready with Cody Eden.
Okay. This is cause number CR 2385, State versus Cody Christopher Eden. Set for docket call today, Mr. Sanders.
Yes, Your Honor. And Judge, Mr. Eden has chosen to reject the state's plea bargain offer of 20-year sentence to TDCJ and ask for a jury trial setting.
Okay. And Mr. Eden, you do understand that if the court sets you for jury selection after you've rejected the state's offer, you're not going to be allowed later by the court to accept that 20-year offer. Do you understand that?
Yes, sir.
Okay. All right. The court will place Mr. Eden on the jury selection docket beginning June 7th. Mr. Eden, if you remain in custody, then paperwork will be sent out there reflecting your new date. If you make bail in this case at any time, then you're going to be ordered to report on your jury selection days at 8:30 at the Van Zandt County Courthouse. And there, a member of my staff will be there to help you with your paperwork. Mr. Sanders will not be ordered to appear at any of your jury selections until he receives notice from the court that your case is likely to go to trial. Okay? All right, Mr. Sanders, if you'll fill out that notice of appearance with that June 7th date, then we'll be adjourned in this case.
Thank you, Judge.
You're welcome.
Okay, we have William Andrew Wilson, which is Mr. Weiners.
Okay. All right, court calls CR 18-521, 522, CR 19-327, State versus William Andrew Wilson III. Mr. Weiner, I show that we're set for docket call on all cases.
Yes, Your Honor, that's correct. The court will probably recall this is my second appearance with my client. I was retained before the last setting. I was able to pick up the digital discovery today while I was in Canton this morning, but I have not had an opportunity to review it, obviously. So I'd like one additional setting so I can, obviously, if I need to file a contested motion, I'd let the state know, but one additional setting so I can continue reviewing everything. And I've also set up a Zoom meeting with my client, so I'll be able to discuss it with him in full.
Any objection from the state?
State has no objection, Your Honor.
All right, court will set Mr. Wilson for docket call on July 1st.
Okay.
All right, Mr. Wilson, we'll see you back on July 1st.
And William, I'll be Zooming with you soon, okay?
Yes, sir.
Thank you. That's all I have, Judge. May I be excused?
Mr. Weiner, is the jail setting up Zooms for you there in Van Zandt County?
They are.
That's great.
Yeah, I tried to see him and I forgot that there's some limitations on court days. I went after this morning's docket. And so I don't know her name, but she gave me her email address and I emailed her and they're supposedly arranging it. So I appreciate it.
Yeah, that's good. All right, great. Yes, sir. You're free to go.
Thanks. Y'all have a good one.
See ya.
Okay, we are down to Ms. Beasley's plea with Mr. Farrell. And the last I heard, he had not gotten here yet. He had had his car overheated, so.
Flores, right? Stephen Flores?
I meant Flores, I'm sorry.
Okay,
We will
All right,
take
well-
a short break.
okay. We'll stand in recess. Are you ready? All right, the court calls CR 2211, State versus Stephen Flores. Mr. Flores has failed to appear at court when ordered. Court has received notification that he may be en route. However, he has failed to appear as ordered. The court at this time is going to find his bond to be insufficient and will issue a warrant for his arrest. Once Mr. Flores is taken back into custody, then the court will conduct a plea if that is still offered to him by the Van Zandt County DA's office. So that will conclude our docket this afternoon, and we will be adjourned.
Thank you, Your Honor.
Thanks, Judge.
Thank you, Mr. Woodwide. Thank you, Ms. Heisel. Yes, ma'am.